What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.
Welcome to another episode of Legal Briefs, an educational program talking about various legal topics brought to you by the law firm of BBKCC attorneys in conjunction with WCTV. Our topic, I'm Bob Bever, a partner with BBKCC, and our topic today is religion and the law. Now I know that sounds like an all-encompassing topic, so we've tried to break it down into what we think might be of some interest and pique the curiosity of the public. Three different concepts: religion in the public schools, religious activities or symbols on public property, and what are allowable or disallowable activities in terms of apparel or appearance of employees in the workplace. Again, we thought these might draw some interest with the public. Joining me for today's show is our firm's newest associate, Aubrey Crist. Aubrey, welcome.
Thank you.
I'm so glad you could join us today. At the outset, I do want to point out that we are not taking sides or points of views, pros and cons. We're just trying to educate the current situation on where things stand legal-wise with the Supreme Court and other courts, and hopefully in that educational process give you a better understanding of what standards they might use or what the courts are looking at as we discuss the topic. I'd also want to show that setting the stage for any discussion on religion and the law is the very first sentence of the First Amendment to the U.S. Constitution in our Bill of Rights, where our forefathers said, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Now let's repeat that. That's how important it was. It was the very first sentence of our Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now that may seem like a simple sentence, but over the period of time it hadn't been so simple, has it, Aubrey?
No.
The first part of this sentence has become known as the Establishment Clause. And many commentators have pointed out that there are probably few issues that divide liberals and conservatives as much as the Establishment Clause. Liberals believe, as Thomas Jefferson wrote, the phrase is meant to create a wall that separates church and state. How many times have we heard about separation of church and state? That's the liberal point of view. Conservatives, however, believe that this phrase means that the government only violates the clause if it coerces religious participation. And then we have the moderates in between that see the clause as forbidding government from endorsing any particular religion. So, unfortunately, there's not a crystal clear answer to a lot of the issues we'll be discussing, and as one of the appellate courts has recently pointed out, the current status of interpreting what is legal or not legal is a hot mess. So, in spite of the confusion that exists, let's get into some specific areas, and our first topic is religion in the public schools. Aubrey, you want to talk about religion in the public schools?
Of course. Well, you've kind of covered the basics of the Establishment Clause. And while there are some issues regarding interpretation, the courts have been able to come up with some evaluation tests in order to find answers to a lot of people's questions out there. Three of the main tests are the Lemon Test, the Endorsement Test, and the Coercion Test.
Lemon Test coming from a Supreme Court case in 1971, Lemon versus Kurtzman.
And that's one of the most commonly known, just the phrase itself, the Lemon Test. It's pretty well known. But just to give you a broad idea of what that is, so the government can assist religion when, and there's three aspects to this. The primary purpose is secular, which means there's no religious or spiritual basis.
This is what test they're using to determine if something is allowable or not. Okay.
Yes. The second part is it does not promote or inhibit religion. And then the third part is that there is no excessive entanglement between church and state.
So if it meets those three tests, something's going to be allowed.
Correct.
Okay.
So then we move to the endorsement test. Essentially what the endorsement test says is that it prohibits an adherence to a religion relevant to standing in political community. So
in that way, it's just kind of looking at to see whether, by allowing this, is the government endorsing a particular religion, which is a no-no.
right. So it focuses on, no excessive entanglement and no government endorsement or disapproval of religion.
And then a third test?
Yes, the last one is the coercion test. And I understand you'll get into this later, but I'll just give you a broad idea. So there's no coercing anyone to support or participate in religion or its exercise, or acting in a way that establishes a state religion or a religious faith.
So with these tests in mind, let's apply those to some specific examples. Take one. You can jump in on any of these.
Well, so with the coercion test, it recognizes an increased challenges involving schools as actors. There are heightened concerns with protecting children from subtle coercive pressure in public schools. So, for example, I've had a lot of questions from teachers and parents about what's allowed during the holidays, such as, decorations and things like that. There aren't a lot of extensive court rulings on Christmas displays in public schools, but governments are barred from erecting explicitly religious symbols unless they're part of a larger secular holiday display. So there have been a few cases, such as Lynch versus Donnelly and County of Allegheny versus the ACLU, which basically states that a school is not prohibited from decorating the building for Christmas, but they're limited to in the kinds of displays.
So they might be able to put up wreaths or trees
Right.
of sorts, but not...
Right. So basically the types of things that are permitted are secular Christmas decorations like reindeer wreaths, Santa Claus, lights, toys, presents, and even Christmas trees. While Christmas trees did originally come from a religion, they've been largely commercialized and it's no longer associated with a religion. Things that are not permitted includes, manger scenes, crosses, angels, or other religious symbols.
Okay. Now, how about being used as a teaching tool, teaching religions? Can that be brought up at either holidays or other times of the year?
Yes, they are. So schools can use religious symbols as a teaching aid or resource, but they can only be used as an example of cultural or religious heritage. So the teachers cannot use that as a means to teach about their own religion.
Again, that would be shown as advocating or endorsing
Right.
a religion. That's
Right.
the no-no.
Right. So also schools can only display these types of symbols on a temporary basis,
Okay.
only during the part where it's part of the academic lesson.
Okay.
Okay?
So, apart from holiday decorations, how about what can a student, teacher do on passing out literature, Bibles? I know when I was young in grade school, the Gideons were at the grade school passing out Bibles.
Right, and that's actually a common complaint where Gideons distribute Bibles quite frequently. To put it simply, distribution of Bibles is unconstitutional when you do it in the school.
On the school. And I think I've seen some cases where if they're down the street and just happen to catch kids on their way home, again, off the public property, may be allowable.
Right. And that's fine if you're on property like that. The main reason, the courts focus on the elementary school students in particular. They just do not have the ability to make the distinction between private religious speech and state-sponsored speech. So it's especially sensitive in elementary schools.
Of course. Prayer in school. We've heard that for years about what has now been prohibited, and that even moves into athletic contests. School hours, after school hours. What's the status of the law as we sit right now, if it is?
Well,
anything?
prayer in schools, not allowed. There have been a lot of issues regarding coaches, sporting events, band functions. What if you all get together for a meal? Are you allowed to pray? For example, there was a in Kinney versus Bremerton School District. There's a Washington assistant football coach, and after the football games, he would get the team together on the 50-yard line and pray. The school sent him several letters asking him to stop. They even offered him somewhere else that he could pray personally. They just thought that going out there in the middle of the football field in front of all the fans right after the game was not acceptable. Eventually, the court found that the coach was speaking as a public employee and not as a private citizen. He was still on school grounds, and he was with all of his students, leading his students. So, essentially,
they said,
because he was in the presence of the students and he refused to change what he was doing, they saw that the speech was directed, at least in part, to the students and the people in the
and
stands.
so therefore, as a public official, he's endorsing a religion that he
Yes.
should not do on public time.
Yes.
Now, how about the students, if a group of students on their own, without their coach, decide to go into the end zone after a football game and pray? Has that been allowed, directly addressed?
It has been addressed. Simply put, it doesn't change anything. Especially, I mean, for example, a lot of people have said, okay, well, what if we put it to a vote? Can majority rule? No.
Because, again, it would be trying to impose that on some of the students that didn't want to do that, and they'd
Yes,
feel...
they'd feel left out, or like one person's religion is better than another's, and so the courts say no.
Now, if we get into either before school hours or after school hours, whether a Bible study group can meet, that kind of depends if the school is open for other types of
Yes.
seminars or
Yes.
activities.
So some schools allow different organizations to come in and use their facilities. When they do that, they are considered an open public forum. In that case, if a school is going to open themselves up to non-religious groups to come in, they also need to allow religious groups to come in. They can't choose one over the other. So when a school does that, the group can come in, but it cannot be during school hours. It's got to be before school, before students arrive, or after school, after all of the students have gone.
Because that's where, and this it's such a thin line, it seems to me, in trying to read a lot of these cases, is that the public entity has to be neutral. So yes, they are allowed to prohibit some things because it looks like they're endorsing them,
Right.
but in some situations, by prohibiting it, it looks like they're going beyond being neutral and being anti-religious,
Right.
and so they can't do that either.
Right.
So it's a thin line. When it comes to the teachers, this gets into some competing civil liberties, does it not, as far as, especially in the higher grades, freedom of speech, the freedom
Yeah.
of speech of a teacher versus this establishment clause of prohibiting religious activities.
Right.
Where does that, what can a teacher feel, can a teacher on their own be talking to others after hours or using the school form?
So there's a lot of different issues in that. For example, a teacher in the middle of the day, say we have silent reading time for a half an hour, no one's talking, you're just reading. A teacher cannot sit at his or her desk and read their Bible because you're sitting in front of the students, they can see that. You cannot have a Bible just sitting on your desk closed. Teachers aren't allowed to do that.
Can't do that.
They
Okay.
can't have it sitting on their bookshelf either. The courts are pretty clear on that issue. In regards to before or after school, it's a little different. So teachers are allowed to participate in these religious activities on school grounds before and after school. However, they cannot be there in a participatory capacity.
I see.
So they can simply go and watch, but they can't participate. They can't get up and lead. So for example, there was a court case where a teacher was a gospel leader, and her gospel group would come to the school in the evenings and practice their hymns and things like that, but she was leading the group. She was found to be in violation.
In violation of the
Yes.
Establishment
Yes.
Clause, yeah.
So if she had been just sitting back and watching, it wouldn't have been a problem. But because she was participating, it became a problem.
And we should point out for this entire discussion, we're talking about public schools, not private schools.
Correct.
A private
Correct.
Catholic
That's
school,
a completely different animal.
story. They
Yes.
are exempted out from
Yes.
some of these things, and of course can have more religious teachings in there. Well, let's move into then our second topic of the conversation, and that's religious activities or symbols on public property as a whole, not just the schools. Fortunately, it's been very timely. Just in late June, the Supreme Court came out with a case, first case that they've dealt with for 5 years, dealing with the Establishment Clause, American Legion versus American Humanist Association. Facts of this case. In 1918, a county in Maryland allowed the American Legion to erect a 32-foot high, huge cross at a intersection in that county of Maryland, honoring the war dead from World War I. 49 young soldiers had perished in World War I in that county, and they erected this cross in 1918. It has stood there for years, and now the American Humanist Association, along with others, challenged that as far as being a violation of the Establishment Clause. After first winning at the local level, then losing at the district court level, it finally went to the Supreme Court, and the Supreme Court ruled 7-2 that that cross may stand. Now, it's interesting, the 7 Supreme Court justices all had different rationales for allowing that cross to remain, but I think some of the overlapping from all of the majority justices was that a lot depended on the age of how long that symbol had been there. There were other secular aspects of that symbol. It was a war memorial for World War I. And at that point, they talked about that crosses were used almost universally to honor the war dead, not just Christianity. And here, one of the justices said that if it was forced to be removed, that end result would be that the removal would be seen as something more than neutral and would be an anti-religious move. So I think the other thing, and I think, Aubrey, you've read some of the synopsises of that case, that they're moving away from the Lemon Test. And did not really utilize the Lemon Test, and said that, I really think because of the conservative nature of our Supreme Court, they're moving more and more towards the Coercion Test, and unless somebody's being coerced to honor that Christian or that other religious symbol, that it's going to be allowed to stand. I get that sense, don't you, from the court case? So, and the other thing that whether one can challenge it or not, the legal word is standing. Do I have standing to challenge something? Well, and some of the more less liberal Supreme Courts have said, if you are offended, you have standing. It looks like now maybe the majority of our justices are saying you need to be showing damaged more than just being offended by it. Because as one of the justices said, in this day and age, anybody can be offended by anything, and so we'd be in court all day long. Right. Another, I thought one of the justices made a good point, that they said, don't look to the courts to solve all of our problems. That sometimes you go to the legislature. If you think that there is something that shouldn't be there, have your legislators vote to remove it instead of laying it all in our lap of the courts. So I think in the years to come, we're going to see some varying opinions from the Supreme Court on that, but that is the most recent Supreme Court case on that. To also show the fickleness or the grayness of this, the 10 Commandment cases. Actually, Wayne County had one where our county did remove the 10 Commandments tablet that was out on its public property. But in 2005, on the very same day, the Supreme Court ruled in a 5-4 decision that one county that had an ordinance requiring the 10 Commandments to be posted in every one of its county buildings, that ordinance was declared void, unconstitutional. 5-4 vote, they could no longer require that in all of their county buildings. But on the same day, the court ruled 5-4 that a memorial showing the 10 Commandments that sits between the Texas State Capitol and the Texas Supreme Court could stand. So many of these are just fact sensitive and, well, just what one justice maybe has in its mind on a 5-4 vote. One vote can change that this is allowed, this isn't. So that's why it's hard to give some clear answers, isn't it?
Right, yeah.
Prayers at public meetings. The last Supreme Court case prior to the American Legion versus American Humanist Association and the 32-foot cross was a case entitled Crist versus Galloway. This is where a town council always opened their meetings with a town prayer. Should that be allowed? Should that not be allowed? Again, on a 5-4 vote, they allowed that to occur because the town had clergy of different faith who had been invited to say the prayers. They also pointed out in that case, which I also think is foreshadowing of what our new court, our more conservative court might say, is that one of the justices in the Green case said that there is the historical practice of having our very first Congress that allowed chaplains in Congress. That showed that the framers considered legislative prayer to be a benign acknowledgement of religion's role in society, where monuments, symbols, and practices with a long-standing history follow in the tradition of that first Congress in respecting and tolerating different views, endeavoring to achieve inclusivity and non-discrimination, and recognizing that an important role that religion plays in the lives of many Americans, they are likewise to be constitutional. I think we're going to see that more and more, that as long as it's inclusive, as long as it's allowing different views, as long as it's not discriminating, that maybe some of these religious symbols or activities are going to be allowed.
Bob, I'm going to
Go
interrupt
right
you
ahead.
for just a minute. I have a question. I just want to make sure we're all following you here. So all of these different members of the clergy were allowed to come in and pray. So my assumption based off of that is that as long as the government is allowing each religion to have their turn, it's allowed. Is that correct?
That's what I would read from that Supreme Court case. Now, there have been still differing that if someone would say, well, is an atheist allowed to express their views at the start? And that has not yet been ruled upon. And so just because the Supreme Court rules 5-4, there's enough leeway that some of our district and appellate courts they find what they want to read in a case and interpret it that way on following cases. But at least the last speaking from the Supreme Court said it this way, and again, as long as it was all-inclusive. And I think it's because it had a history of it. And I'm seeing that. Someone said that, for example, that cross in Maryland that was allowed to stand, had they just now erected it, maybe it wouldn't be allowed. But because of its significance over a period of years, has made it more of a historical monument to that community and what those people believed in, and to remove it is different than maybe allowing it to stand today. Same thing maybe could be said for the prayer. Nativity scenes. We've heard about nativity scene cases, and this there have been some creative alternatives. On the forefront, I think, as you pointed out, in the schools, same thing's going to apply on public property, that a public body cannot, in front of its town hall, erect a nativity scene because of its Christian denomination on it. However, a recent case in New York said there is a distinction between it being close to a city building where governmental business is and what might be considered a public forum. As a result, the Catholic League was allowed, and I didn't know this until this last weekend doing some research, the Catholic League in New York was allowed to erect a nativity in Central Park across from the Plaza Hotel on Fifth Avenue because it was a public forum, so there was a freedom of speech. So apparently a Jewish organization set up their little symbols down the road, and others could speak freely on a public forum, so there could also be a distinction between a public forum location and what might be viewed as endorsing something from a city building, which I thought was curious. All of this kind of takes us into religious activities, dress, and appearance. What can an employee do? I think the general rule is that, and this gets into the Civil Rights Act versus the Constitution that says no one may be discriminated against due to race, color, religion, sex, or national origin. So consequently, employers cannot discriminate against employee if they have a sincere religious belief. And so they must accommodate them unless it is too burdensome on the employer. And that's not as significant as the Americans with Disability Act, which requires a significant difficulty, but it's not too burdensome. And this could involve dress, facial hair, days off, prayer time. I was going to give, we may be running short on time, but some examples to Aubrey of what might or might not be allowed. A retail salesperson in a national clothing company wanted to wear a headscarf because of her religion. policy said no headgear. May they prohibit that headgear?
My guess would be no,
They
can't.
cannot. But what is interesting is because they have a color scheme, they did say that reasonable accommodation for both sides is she can allow the headgear, but it must be in the color of that national
That
thing.
makes sense.
Another example was not allowing beards in their workplace for managers. Well, because of some religious views that say they have to require beards, they said, nope, that is not allowable. Here's one. How about for safety concerns? In a hospital, no beards were required or were allowed. And in the Sikh religious sect came and said, well, I want a beard. They said what they proposed as a reasonable accommodation was to be able to put on 2 sterile cloths over the beard. The employee still refused to do that. Do you think the employee succeeded on that?
I do not.
He did not. That was a reasonable accommodation. And again, all of these must be sincere beliefs. I can't just come to work one day and say, oh, I think I want to wear a beard today, and sure, it's going to fit that religion. It's got to be a sincere belief on that. So we have to look at, again, the fact situation of each case. Some 2 recent cases, the UPS had a non-beard policy. They paid $4.9 million as an EEOC settlement in late 2018. And then just this year, the EEOC brought suit against Walmart because they had an employee who wanted to take off Fridays from sundown to Saturdays at sundown to observe their Sabbath. That one is still pending, and I think that'll be interesting because is allowing them to have that day off a reasonable accommodation that should be expected or not. So we'll look to see if that ever reaches the Supreme Court. So I know we could talk for hours about all of this time, but hopefully we have shared some things that have been of interest to the public. We've not even touched on the subject of competing constitutional rights, such as religious liberties versus other personal liberties like sexual orientation, but that could probably be a topic for another day. So, Aubrey, thank you for your assistance and input in this discussion.
Thank you.
And thank you for joining us and tuning in for another episode of Legal Briefs. We hope that you will join us next time for Legal Briefs brought to you by BBKCC Attorneys. I'm Bob Bever. Have a good day.
What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.